As we all know, no one wants to deal with probate if they don't have to. It's a long and expensive process. And for those of you that aren't familiar with what probate is, basically, probate is a process where the court recognizes a person's death, oversees the payment of any debt they left behind, as well as distributing their assets, like their home. Key factor to remember here: the way someone currently holds title to their property will determine whether or not their family members have to deal with probate upon their death. So, if the property isn't held in a trust and the current owners pass away, then most likely probate will be required. Additionally, please note, a will is not the same as having a trust. A will not avoid probate. However, a will speed up the probate process, but the estate will still need to be probated. So quickly, I want to go over what title will require in order to close a probate sale transaction. The first thing to discuss with the attorney is whether or not they have the court-issued letters yet. Two types. One, letters of testamentary. That's when the decedent has a will. The other type is the letters of administration. That's when the decedent has no will. These letters will either grant to the executor full authority or limited authority. Full authority is much quicker than dealing with limited authority. Limited authority requires much more paperwork, more court supervision. The court must approve the sale, and things tend to get dragged out, and there's also appeal periods that we have to deal with. Starting off with full authority, when we have letters authorizing full authority, what is required? Keep in mind, when we have full authority, at that time the executor can work with you, the realtor, to put that probate listing on the market, and you can begin accepting offers. With full authority, obtaining court approval is not required, meaning you can accept a buyer's offer as long as the beneficiaries all agree to the purchase price. Here is what title will require. 1, we're going to need a certified copy of those letters granting full authority to record at closing. 2, we're going to require a copy of the filed notice of proposed action. Now, this document states the name of the buyers, the sales price, the purchase agreement. This goes out to the beneficiaries, the heirs, and they have 15 days to object. In situations like when there's an upcoming foreclosure where you don't have 15 days, if the beneficiaries all agree, they can sign a waiver waiving those 15 days so that the sale can close right away. 3, we're going to ask for a letter from the attorney basically stating that no objections to the notice of proposed action have been filed and that the time frame for filing any objection has expired. When we have letters authorizing limited authority, what is required? 1, we're going to need court approval. So we're going to need a certified copy of the order confirming sale of real property. 2, there's also appeal periods to deal with. These appeal periods can be waived if all the beneficiaries agree. They can sign a waiver and it can usually be waived. Lastly, there's certain verbiage that needs to be added to the grant deed. Escrow will do this for you, but it's verbiage that basically states that this grant deed is pursuant to the probate case. For further details and more information on how to close a probate transaction, please contact your trusted probate attorney. As I discussed, this was just a template from a title perspective. I'm not an attorney. But if you do have more detailed questions, I'm here to help you. I can also connect you with some of these attorneys as well. Have a blessed week and talk to you soon.